Okay, good morning, everyone. Welcome to the disability meeting for September 2019. Please make your introductions to the record.
Deputy Designate for Commissioner O'Neill.
Susanna Vickers, designate for Controller Scott Stringer.
John Dorso, alternate designate for Controller Scott Stringer.
Cynthia Collins, designate for Mayor Bill de Blasio.
Phil Dukes, designate for Finance Commissioner Jacques Villar.
Marta Ross, Law Department by invitation.
Amy Cassidy, Law Department, present by invitation.
Joe Alejandro, PBA.
Chris McGrath by invitation.
PBA. Mark Marino, PBA by invitation. Gary Direct. Who?
Gary DeRosa, SBA, present by invitation.
Anthony Bradley, designate for Ed Mullins, SBA.
Nick Safuni as counsel, SBA, LBA, CEA. Lou Turco, LBA.
Roy Richter, CEA.
Kenny Sparks, DEA, designate for Mike Palladino.
Karen Paxtis, DEA by invitation.
Jeffrey Ward, DEA, by invitation.
Keith Snow, Office of the Actuary, by invitation.
Chief Surgeon, present by invitation.
Bob Senskestead, Pension Fund, present by invitation.
Kevin Holleran, Pension Fund by invitation.
Anthony Antonellis, Medical Division, present by invitation.
Vincent Diaz, Pension Fund, present by invitation.
Nicole Jambrisi, Police Pension Fund, present by invitation.
Stanley Thomas, Pension Fund, by invitation.
John Flynn, Police Pension Fund, present by invitation. Roger Stern, Police Pension Fund, by invitation.
Mary Young, Police Pension Fund, present by invitation.
Marty Williams, DEA, by invitation.
Manuel Salas, Police Pension Fund, by invitation.
Fernando Pension Fund, present by invitation.
Thank you, Joe.
At this moment, I'd like to take a personal privilege and read the following into the record. On September 11, 2001, New York City came under terrorist attack. Almost 3,000 people died. The NYPD responded to the World Trade Center buildings in a show of strength and courage that earned us the respect of the world. 23 brave members did not return from ground zero. We honor them daily by protecting the American way of life, for which they died on that day. We take pride in knowing that history will remember that the New York City Police Department demonstrated the highest principles of service and humanity in our response that day. May events never require us to do so again. I will now recall the members lost on that day. Sergeant John Kaufman, Sergeant Michael Curtin, Sergeant Rodney Gillis, Sergeant Timothy Roy, Detective Claude Richards, Detective Joseph Vigiano, Police Officer John Delara, Police Officer Vincent Dans, Police Officer Jerome Dominguez, Police Officer Stephen Driscoll, Police Officer Mark Ellis, Police Officer Robert Fazio, Police Officer Ronald Cloffer, Police Officer Thomas Langone, Police Officer James Leahy, Police Officer Brian McDonald, Police Officer John Perry, Police Officer Glenn Pettit, Police Officer Morris Smith, Police Officer Ramon Suarez, Police Officer Paul Talty, Police Officer Santos Valentin, Police Officer Walter Weaver. And may we also remember and honor our members who served the department during the attack and who died from illness contracted while performing duty at 9/11 sites. I now ask for a moment of silence. Thank you. Okay, moving on to the meeting. On page 1, to accept the minutes of the previous meeting, Wednesday, August 14, 2019. To confirm the next meeting date, Tuesday, October 15, 2019. Article 2, pages 2 through 10.
Nothing of a controversial nature, Joe will so move it.
Thank you, Kenny. So move pages 2 through 10. Page 11, the election of officers as provided in Rule 10 of the Rules and Regulations governing conduct of the Trustees of the Police Pension Fund, Article 2.
All right, Joe. As provided in Rule 10 of the Rules and Regs governing the conduct of the Trustees of the Police Pension Fund, Article 2, the first regular meeting of the Board held in September of each year shall be the annual meeting. For the election of the following officers, First Vice President, Patrick Lynch, PVA incumbent. Are there any other nominations? Hearing none, show the ballot is closed and, or I should say, the election closed and one ballot be cast for Patrick Lynch as the first Vice Chairman. Position of second Vice Chairman, Roy Richter, CEA, incumbent. Are there any other nominations? Hearing none, show the nominations closed and one ballot be cast for Roy Richter as the second Vice Chairman. Position of Secretary, Louis Turco, LBA, incumbent. Are there any other nominations? Hearing none, show the nominations closed and one ballot be cast for Louis Turco as the Secretary of the Board of Trustees. Thank you very much.
Do we have a sergeant at arms?
No. Would you like to create a position for you, John?
Or be nominated?
Possibly next week.
We'll nominate you.
If it comes with a fancy jacket, he said.
Wow. Okay, that election being over, and once again, I'll point out, Pat Lynch is unopposed in another election. There you go. Pages 12 through 99, fiscal year 2019 actuarial valuation report.
Good morning. This is just for distribution. No action is required. It's the fiscal year 2019 actuarial valuation report for the Police Pension Fund. It reflects the contributions and the assumptions and methods that the board previously adopted. And if there are any questions on this, please reach out to Sherry. She'll be happy to answer.
You can bet we will have some questions. All right, thank you. Page 100, resolution. Controller as custodian of the funds.
Nothing of controversial nature?
Being that it's the same resolution as we've had in the past, I make a motion that we accept it for the next quarter.
Okay.
I'll second.
Okay. All right. That is the reading of the, excuse me. And I make a motion that we go into.
Actually, Joe, before we go into
there you go.
exit the public session, I'd just like to raise one issue, and that is there was a recent FOIL decision in regarding a FOIL request filed by the Empire Center for Public Interest against the Police Pension Fund, and I see the lower court ruled against the pension fund and against the city, and I'm hopeful that the law department is processing the appeal of this decision, consistent with previous decisions that have been rendered going all the way up to the Court of Appeals in the past. However, just on a
Hey, Roy, can I don't know if we should be doing this in the public.
yeah,
I think it has to be, but we were discussing this.
the public, we can go into confident, if you want to break into attorney-client afterwards, maybe we could do that. But I just wanted, one of the concerns that I had in the decision was, and this is a public decision, the respondent emailed a spreadsheet to the petitioner that included the retiree's retirement date, service year's appointment date, and yearly and monthly benefit amounts. And of course, it did not include a personal identifier for the retirees, given the dramatic safety issues that police retirees face. As I was looking at that decision, I came to the understanding that the spreadsheet that was released was actually a misleading spreadsheet, and it was a misleading disclosure, even in its limited form, because it included a combination of two specific retirement benefits. One, of course, is the defined benefit amount, which is statutory in nature based upon years of service, and it's publicly funded. But second is it included an annuitized value of a defined contribution amount. And just to go into the defined contribution amount, each member has the ability to contribute a percentage of their salary based upon their age. And that contribution then goes into the annuity savings fund held by the Police Pension Fund, and it grows at a statutory interest rate, and it's also subject to a limited employee match to the extent a member takes advantage of ITHP waivers. With to the extent that that amount is disclosed, it actually, in reviewing it, it violates various federal privacy protections, one being the Privacy Protection Act of 1974, and then secondly, more recently, there's the Gramm-Leak-Biley Act, which requires a number of protections, but also requires an annual disclosure to beneficiaries and members that participate in any type of defined contribution retirement account, including 401ks, defined benefits, and or defined contribution amounts, such as what the police pension fund holds. And my concern is that this wasn't raised in the initial trial court level, and that the disclosure, limited in nature as it is, was misleading to both the court and to the plaintiff in the action, and that to the extent that names are subsequently attached to it, it actually exposes the Bureau of Asset Management, State Street, which is a custodian of our funds, the Police Pension Fund, and the City of New York to liability and an individual private right of action by each of the 50,000 beneficiaries and pensioners of the Police Pension Fund. So my request is twofold. One is I would ask the Police Pension Fund, the General Counsel, or the pension fund as a whole, not just the General Counsel, to provide the initial privacy notice that we receive, that we give to our members, the annual privacy notice, the current privacy notice, and any other disclosures or notices regarding privacy rights, which the pension fund may receive from those financial institutions which are required to generate that. And I'm not quite sure if the pension fund itself is supposed to generate that, but I know that the federal statute does require a State Street to generate those privacy notices. And then, and secondly, I guess the law.
Respectfully, in order to maintain attorney-client privilege, any request that you're making of your counsel, we would ask that we go into attorney-client for that, just so that there is no issue with any sort of privilege being violated. If it's a request that you're making as a trustee to your counsel, I think it'd be more appropriate to do it in a more private setting, just for everyone's protection.
So I thought we had talked about this. We really didn't get I understand the opinion on attorney-client, and I know there was an issue regarding the stenographer regarding attorney-client, but I'm always concerned about going into attorney-client because much of the conversation we have does not get recorded and doesn't really address the concerns of every member of the board. We understand that you're attorneys, but it seems like some of the ideas and thoughts of part of the board don't get addressed when we go into attorney-client. Things get diluted. So it's my fear that some of the concerns of the trustees, when you go into attorney-client, some of the ideas or thoughts don't get addressed ultimately. So, and I don't have an answer for that. I think you need to answer that.
Well, just as a representative for the law department, we always, everything that is said to us, we always try to take it back, especially those that attend this meeting, and we try to be, very diligent in addressing all of your concerns.
So I guess just broadly, without getting into the specifics, I'm concerned that these issues weren't raised in the court decision, and actually not necessarily in they weren't addressed in this court decision, which has been released. And
to tie that in with Roy, I would like an answer as to were they even considered when these arguments or your strategy was being crafted to go into court.
So, Joe, as a trustee, when we start talking about legal strategy and litigation strategy, I think that really appropriately should be discussed because we don't want to telegraph to the plaintiffs what our legal strategy is or what our deliberative process is, because then we could waive that entirely and then they could depose us.
But hasn't that, in part, again, I'm not an attorney, but hasn't that strategy already been argued and brought into court? So the question I'm asking now is, the point that Roy is bringing up, was it considered? Roy's brought up a valid point. Was it considered? Because then there's another thing that needs to be addressed. Why wasn't, if it wasn't considered, why wasn't it considered? And were we completely represented? Because I was not asked about this when the strategy was being crafted.
Joe, I do not mean to overstep, but going into conversations about things that were said to trustees. I really just, as your counsel, in order to protect everyone, and this case stems from trying to preserve privacy, I would really recommend that any further conversations about this particular matter be done in a more private setting. If we're going to be going into strategy and things said to certain trustees, just for everyone's protection.
And I think also, though, in an effort to protect our rights, because we do want a written record in this matter, is there an issue if we go into attorney-client where the stenographer, in fact, stays for the discussion?
So in order to address that, would it be okay if we went into attorney-client, because we would be giving you advice as your counsel in order to address that, and we can address that very limited topic in attorney-client, and then if needed, go back into having the stenographer present based off of the determination of that conversation. I apologize for the.
Okay, but I understand and appreciate everything that you just said. I just wanted to make sure that for the public record, that not only does this decision that was rendered by the lower court place our retirees in harm's way, and not just by theoretical harm's way, but there's specific instances of our retirees being placed in harm's way, and but secondly, that it also doesn't address serious privacy issues that subjects not just the individual to a violation of their own individual rights, but it would subject the fund, the Bureau of Asset Management, State Street, and the City of New York to liability from a multitude of other aggrieved individuals.
And just one more thing, is there an essence, a time of the essence kind of with regards to this decision, when it has to be complied with, when any potential appeal or re-argument?
Motion for re-argument.
Motion for re-argument. Is there a time of the essence kind of?
Motion.
So
If we
again,
were served with notice of entry.
This is not changing strategy. This is just about, go ahead, I'm sorry.
Wait, do we know if we've been served with notice of entry? I mean, we got the decision at the end of August. We don't.
I'm sorry, I didn't hear you.
We would have to inquire as to if the timing has.
Well, if it was, what would it be?
Would it be okay? I apologize for being that overly cautious attorney. However, given the sensitivity of this case and the fact that we are trying to desperately protect these members' privacy and we don't want to accidentally do anything that would potentially harm the litigation, would it be okay if we went into attorney-client to discuss some of these more nitty-gritty details? Again, just given the sensitivity of the matter.
Everybody okay with that?
Yeah.
Yeah, so let's go. I make a motion to go into attorney-client privilege.
do you want to exit?